As we get started, I'd like to introduce to you today's presenter, Jennifer Damon, AccuSource's Compliance Manager. Jennifer has over 10 years experience in the background screening industry and graduated from the University of Akron School of Law with a Doctor of Law degree. She is an experienced compliance professional with knowledge from the employer and consumer reporting agency side. She has performed various roles in the industry, including interpretation of criminal and civil record summaries, managing quality control, and managing the E-Verify program, including audits for billion-dollar facility service companies. She has experience with government clearances and contract review. Jennifer is responsible for our compliance department, including federal, state, and local legislation changes and industry accreditation. Additionally, she oversees the quality assurance process. Now I'll turn it over to Jennifer.
Good morning and welcome to the webinar. We will be addressing a number of topics today and will be answering questions at the end of the presentation. Please send any questions you may have and I will address as many of them as possible or will follow up with those that cannot be answered during this hour. Today we'll be covering a review of 2018, which was a very busy year in the background screening industry, as well as changes and trends anticipated for 2019. More specifically, our 2018 review will include the new consumer disclosure required by Senate Bill 2155, an update on fair chance legislation, also known as Ban the Box, new salary history bans, court decisions on standing made in the wake of Spokio versus Robbins, updates in the world of privacy, including GDPR and California's version of GDPR, and a discussion of recent marijuana legislation. We will then discuss anticipated legislation and trends for 2019, as well as best practice recommendations. Before I start with the 2018 review, please keep in mind the following. The content provided in this presentation is for informational purposes only. It should not be construed as legal advice or serve as specific guidance. AccuSource strongly encourages current and prospective clients to seek the advice of qualified counsel, preferably specializing in employment law, prior to engaging in any legal decisions involving drug and/or background screening policies or compliance concerns. Please also keep in mind that this is a general discussion. I will not be covering specific state laws and exemptions. For example, some employers may have exemptions to the general laws due to their industry or the type of position. It is best to discuss your specific business needs with legal counsel to ensure that you are compliant. Our discussion is limited to criminal records. We will not be discussing credit reports, which are governed by federal law and are also restricted by certain state laws. First, we will discuss the new consumer disclosure that must be provided under the Federal Fair Credit Reporting Act. Effective September 21st of this year, Senate Bill 2155 amended the federal FCRA. The new language requires that an additional consumer disclosure be provided to consumers relating to the consumer's right to request a security freeze from consumer reporting agencies. While only a credit reporting agency, such as Equifax, must place the actual security freeze, all consumer reporting agencies are required to provide the new disclosure, including background screening companies. Employers who fall under the FCRA, for example, those who request credit or background checks, are also required to provide this notice. An employer typically provides a summary of rights during the adverse action process and must provide the updated language during that time as well. Luckily, the Consumer Financial Protection Bureau has assisted the industry and employers by providing an amended FCRA summary of rights that now includes the new disclosure. If you have not already updated your procedures to include the amended FCRA summary of rights, you should work with your legal counsel to determine your specific obligations and whether you need to use the updated summary of rights. Another hot topic that has been under discussion for years is fair chance laws, also known as ban the box. These laws prohibit employers from asking about criminal convictions before a certain point in the hiring process, typically before a conditional job offer is made or before an interview is conducted. For example, an employer in a ban-the-box jurisdiction usually may not include questions about criminal convictions on the initial job application. In other words, they are banned from including a checkbox asking if the applicant has been convicted. As the name fair chance law suggests, fair chance laws allow applicants with prior convictions to not only obtain an interview, but also advance to a certain stage in the hiring process before being asked about prior criminal history. Additionally, these laws may require that the background check process start later. In these jurisdictions, employers cannot use background checks to screen out potential applicants. 3/4 of the U.S. population lives in a jurisdiction that has banned the box, including 31 states and over 150 jurisdictions with ban-the-box laws, including cities, municipalities, and counties. It spans a variety of employers, including public, private, or both. Last year, California passed ban-the-box legislation that became effective on January 1st, 2018. Prior to 2018, California already had restrictions on the types of criminal records an employer could consider when making a hiring decision. For example, California employers cannot consider or ask about certain types of criminal records, including an arrest or a detention that did not result in a conviction, certain marijuana infractions and misdemeanor convictions that are older than 2 years, referral to or participation in any pretrial or post-trial diversion program, an arrest, detention, processing, diversion, supervision, adjudication, or court disposition that occurred while a person was subject to the process and jurisdiction of a juvenile court, convictions that have been sealed, judicially dismissed, expunged, or statutorily eradicated by law, and any non-felony conviction for possession of marijuana that is older than 2 years. California has updated its fair chance law through Assembly Bill 1008. It became effective on January 1st, 2018. Previously, only state and local agencies were subject to the ban-the-box laws and were prohibited from asking an applicant to disclose criminal conviction information until after the employer determined that the applicant was qualified for the position. However, Assembly Bill 1008 makes this requirement statewide, extending the requirement to all employers in California if the employer has 5 or more employees. Ban the box now applies to private employers with this bill. How does this new bill affect California employers who have at least 5 employees? First, they cannot include any questions seeking an applicant's criminal history on any application. In other words, the box has been banned. They also cannot inquire into or consider the conviction history of an applicant before the applicant receives a conditional offer of employment. And they also cannot consider, distribute, or disseminate information about any of the following while conducting a criminal background check: an arrest that did not result in a conviction, subject to the exceptions in the Labor Code, specific section is available, referral to or participation in a pretrial or post-trial diversion program, and convictions that have been sealed, dismissed, expunged, or eradicated. Once an employer has made a conditional offer of employment and has run a criminal background check, Assembly Bill 1008 requires that an employer must first perform an individualized assessment before denying an applicant a position solely or in part because of criminal history. The purpose of the individualized assessment is to show that criminal history disqualifies the applicant because it links to specific job duties of the position. The assessment must include a consideration of the factors outlined by the Equal Employment Opportunity Commission, or EEOC. The employer must consider the nature and gravity of the offense and conduct, the time that has passed since the offense or conduct and completion of the sentence, and the nature of the job held or sought. The employer is not required to provide the results of the individualized assessment in writing, but is permitted to do so. However, the employer is required to notify the applicant of its preliminary decision in writing, including the disqualifying conviction, a copy of the background check, if any, and inform the applicant that he or she has the right to respond within at least 5 business days. If the applicant timely notifies the employer in writing, the employer must give an additional 5 business days to respond. Finally, the employer must notify the applicant in writing of the final decision. Several other jurisdictions have enacted ban-the-box laws this past year. Kansas passed a law that applies to state employment in the executive branch. The law requires that applicants are not asked about their conviction or arrest records during the initial stage of a state employment application. Michigan's law applies to state employment as a whole and prohibits state departments and agencies from including questions about conviction or arrest history on job applications or job postings. Washington State has taken ban-the-box a step further, requiring all public and private employers in Washington to comply. Employers must delay questions about criminal records and background checks until after they have determined whether an applicant is qualified for the position. Employers also cannot categorically exclude applicants with criminal records before determining whether they qualify for a position. Finally, employers face restrictions on how they can advertise job openings, ensuring that those with records are not excluded from applying. Besides the 3 states discussed, other jurisdictions have also enacted ban-the-box laws. However, due to the amount of individual jurisdictions and our limited time, we will not discuss these in detail, but be aware that they do exist. As you can see, many jurisdictions already have ban-the-box in some form, and others are joining each year or at least considering whether to enact fair chance laws. While you should always discuss employment law decisions with your legal counsel, we recommend reviewing legislation closely and consider removing all questions related to an applicant's criminal history. Doing so can lessen confusion and prevent accidental noncompliance, especially for multi-state employers. Another popular topic among jurisdictions is whether employers should ask about previous salary. Previously, various jurisdictions have banned employers from asking about salary histories, at least during some part of the hiring process. The goal of these bans is to address pay equity issues that are due primarily to gender. We will be discussing those jurisdictions which either enacted bans or passed legislation in 2018 that will be effective in 2019. Numerous states have salary bans, as well as some localities such as cities and counties. We will first discuss California, which is the largest state to enact a statewide salary history ban. Assembly Bill 168 went into effect on January 1st, 2018, and applies to all California employers regardless of size and industry. It includes state and local governments as well as private employers. With this ban, California employers cannot ask about an individual's salary history. In addition to the statewide ban, San Francisco also passed its own salary history ban. The new law went into effect on July 1st, 2018. Under the city ordinance, employers cannot ask about or consider an applicant's salary history when setting that applicant's pay. They also cannot disclose a former or current employee's salary information without his or her consent. Connecticut also passed a statewide ban on asking for salary history, which goes into effect on January 1st, 2019. The exception is that a Connecticut employer may consider the history if the applicant voluntarily discloses it. Hawaii's statewide ban goes into effect on the same date and is similar to Connecticut's law. Employers cannot ask about an applicant's salary history unless it was voluntarily provided. However, it differs from Connecticut's law because it specifically does not apply to internal candidates. Chicago, Illinois passed a law that only affects city departments, who are not allowed to ask for salary histories. This law went into effect on April 10, 2018. In Louisville, Kentucky, the government may not ask job applicants to disclose salary histories unless specifically excluded by law, which went into effect by May 17, 2018. Both Massachusetts and Michigan have passed statewide bans, both effective in mid-2018. In Massachusetts, an employer may verify salary information if it was volunteered by the applicant. The City of Kansas City, Missouri may only ask about history once an applicant has been hired at an agreed-upon salary. New Jersey's statewide ban prevents state agencies from asking about or investigating salaries, while New York State has a statewide salary history ban that was effective in 2017, but Westchester County passed its own law in 2018. Pennsylvania and Vermont passed laws in 2018 that ban salary histories statewide. Pennsylvania's law applies to state agencies, while Vermont's, on the other hand, applies to all employers. If a Vermont applicant discloses salary information, an employer may only confirm it after a job offer has been made. While you may or may not be based in a city or state that currently has salary history bans, keep in mind that you may have job applicants who do live in such jurisdictions. You should review with your legal counsel to determine if any salary history questions during the hiring process are appropriate for your specific situation. In 2016, the U.S. Supreme Court reviewed Spokio v. Robbins, which provided some guidance on whether a person has standing to bring a lawsuit in federal court without actually proving harm. The court held that a plaintiff must prove actual injury. The injury must be concrete and particularized. Based on this finding, a bare procedural violation may not be enough, including in cases alleging injury under the FCRA. Why are we revisiting a case from 2016? Because we now have examples of the court's holding being applied in cases from 2018. The first case we will discuss is Bogert versus Kelly Services, a Missouri FCRA class action. Kat Burgett sued staffing agency Kelly Services, claiming that its disclosure form contained extraneous information in violation of the FCRA. He also claimed that Kelly Services did not provide him with a copy of the background screening report or a summary of rights. The Missouri Court of Appeals dismissed the class action, finding that Bogert did not allege an actual injury. His claim was based solely on a bare procedural violation, which was not enough to establish standing. A Nevada district court also had a similar finding in Williams v. TLC Casino Enterprises. The plaintiff class argued that the casino had extraneous information on its disclosure forms, but the district court dismissed the class action. As in Bogert, the Nevada court found that the plaintiff alleged a bare procedural violation of the FCRA. Since it did not prove a concrete injury, it lacked standing to sue. What can we take away from these applications of Spokio? First, Spokio itself and the two applications of Spokio show promise for the industry, including consumer reporting agencies and employers who face FCRA violations. A sufficient injury must actually exist. Bare procedural violations are no longer enough on their own to establish standing. However, while the Missouri and Nevada courts dismissed their respective cases, other courts may not find the same way. It's important to review your documents and procedures with your legal counsel to ensure compliance and review or reduce your risk of a class action under the FCRA. Privacy has been a huge concern in recent years, so much so that different countries and other jurisdictions are creating law that protects the privacy of their citizens. The most notable passed in 2018 is the General Data Protection Regulation, or GDPR. It applies to all organizations that process data belonging to European Union citizens. It provides EU citizens with more control over their personal data and strengthens already existing protections for that personal data. Because it applies across the countries of the EU, It allows for consistency among those nations and how data is handled and protected. GDPR has similarities to existing privacy law in Europe, but does have some new requirements. There are two groups of organizations that have access to personal data: controllers and processors. In the screening industry, the background screening company is the processor of data, while the client is the controller of data. Both groups have responsibilities to protect data and can be held liable for the compromise of data and for failing to comply with GDPR. Because GDPR is a complex regulation, we cannot discuss it in detail today. However, we wanted to bring it to your attention in case you have employees or applicants in the EU so that you can determine your obligations, if any. As an organization that handles the personal data of applicants, you must ensure the security of your IT systems. You should also have procedures in place for how and when to contact necessary parties if any personal data is breached. Even if you do not screen any European Union citizens, you may still be affected by a similar data privacy law. In 2018, California enacted the California Consumer Privacy Act of 2018. It has been referred to as the US GDPR because of its similarities to GDPR. As with GDPR, it seeks to protect the personal data of California citizens, especially those who are 16 or younger. Because this law does not go into effect until January 2020, we will address it in a future webinar, but wanted to put it on your radar for 2019. Another issue currently faced by many employers is how to approach drug testing due to the increase of jurisdictions with marijuana use laws. Because there is no standard rule on whether employers can test for marijuana, and because marijuana remains illegal on the federal level, employers can be unsure on how to handle employees who smoke weed. First, we will review the legislation passed in 2018. Missouri and Utah both passed legislation that legalizes medical marijuana in some form. Michigan, on the other hand, which already had medical marijuana, took it a step further and legalized marijuana for recreational use. The question is how these newly enacted laws will affect employers in those states when it comes to their drug policies. In general, the answer is yes. Employers can still drug test in many of the states that have legalized marijuana in some way, but it is not a black and white answer across all jurisdictions. In addition to whether an employer can drug test for marijuana, an employer must also consider how it can test for current usage of marijuana. Here's a quick summary of some of the new marijuana legislation. Michigan passed Proposal 1, which legalizes recreational marijuana for those 21 and over. However, employers are not required to permit or accommodate marijuana use or being under the influence of marijuana while working or on the employer's property. Employers may take action against employees who violate drug policies or who work while under the influence of marijuana. Missouri legalized medical marijuana in the November 2018 election under Amendment 2. It applies to 9 qualifying conditions. However, a licensed physician can also recommend medical marijuana for any other chronic, debilitating, or other medical condition, which greatly expands the possibility of medical marijuana beyond the pre-approved 9 qualifying conditions. How does this affect employers in Missouri? Employers who use medical marijuana are not permitted to bring claims against employers, former or prospective, for wrongful discharge, discrimination, or similar cause of action due to the individual being under the influence of marijuana while at work. Utah also legalized medical marijuana under Proposition 2. As with Missouri, it is limited to 11 qualifying conditions, but additional conditions can be approved on a case-by-case basis. The medical marijuana user must receive a recommendation from a licensed physician. The effect on employers is a bit different from the other states we discussed. Employers cannot refuse to hire, suspend, terminate, take adverse action against, or otherwise penalize an individual solely for their status as a medical marijuana card holder. However, there is an exception if failing to take adverse action would cause the employer to lose a monetary or licensing-related benefit under federal law. Employers are also exempt from paying for or reimbursing the cost of marijuana, a marijuana product, or a medical marijuana device. With new marijuana legislation comes questions on testing for usage of marijuana, which causes another issue for employers. Marijuana testing differs from alcohol testing. An alcohol test can show if a person is currently intoxicated by alcohol. However, it is not possible to test to determine if a person is currently under the influence of marijuana. A positive marijuana test could show marijuana that was ingested days or weeks ago, so it is not a good indicator of whether someone is intoxicated due to marijuana use in that specific moment. Because there is no accurate test, an applicant or employee can use marijuana legally but still have a positive drug test result. While there is no clear answer as to how employers should approach this issue, it is recommended to treat applicants and employees in the same way, taking into consideration any applicable state or local laws relating to marijuana use. Overall, states' marijuana legislation laws do support employers who want to test for marijuana use and take action against applicants and employees who use marijuana even if that use is legal. "2019 is less than a month away. What can we expect in the new year? Generally, we can expect to see more of the same. Ban the box legislation keeps gaining steam, and we will likely see more jurisdictions joining the movement or expanding already existing laws. While there are fewer salary ban jurisdictions currently, this issue has come into the forefront because of the salary discrepancies between men and women. We will also see additional courts apply spokio when reviewing FCRA procedural violations and determining further what counts as a concrete injury under the Constitution. Privacy will also be a focal point for 2019 and beyond. Other states and even the federal government may look to GDPR and California's privacy law and enact their own laws. Marijuana will continue to be a hot topic. As more jurisdictions legalize marijuana, either medical or recreational, we hope that the courts will provide guidance as to the rights of employers when it comes to drug testing for marijuana use. Perhaps we may see a federal marijuana law that would legalize marijuana on a federal level. AccuSource will keep you posted of any industry trends and hot topics as we learn of them. AccuSource is happy to recommend some best practices. First, thoroughly review your background and drug screening procedures as well as hiring practices to ensure that you are compliant with any new laws. Ensure that you are using the most recent version of the FCRA Summary of Rights. This version includes the new consumer disclosure required under the FCRA, and using it will allow you to become easily compliant with the new requirement. Review your employment applications and hiring practices to make sure that you are not seeking information about criminal history. While you may not be based in a ban-the-box jurisdiction, you should be aware that many jurisdictions do have restrictions. Similarly, be aware of any salary history bans in your state or locality. Watch new privacy laws closely and determine if you need to be compliant with any that are already in existence, such as GDPR or California's privacy law. Finally, remember to keep a close eye on the legalization of marijuana, especially court decisions regarding whether an employer can still drug test for marijuana and how such decisions affect your workplace. We have reached the end of this presentation, and I will now answer questions that we have received.
Thank you, Jennifer. We will now take our viewers' questions for the remainder of our time. If you have not had a chance to ask questions via our chat box, please feel free to do so now. Dustin?
All right. My name is Dustin Mikesell with AccuSource, and I will be reading the questions from the audience to Jennifer for her to respond. The first one that we have, Jennifer, is the summary of rights required to be given to all applicants completing the form, only when taking adverse action, or both?
Generally, you're not required to provide the summary of rights up front. However, it is greatly recommended so that way applicants are aware of their rights from the very beginning. And it absolutely is required during the adverse action process.
Right. The second question, it's a little bit vague. I believe it came in during the discussion about ban the box. The question is this for all types of businesses? Again, it's vague, so if that's regarding the information that you provided, is that for all types of businesses regarding ban the box?
So ban the box is interesting because based on the jurisdiction, it could apply to private employers, it could apply to just public employers, and sometimes even as specific as to city departments. So in order to really answer your question, I would need to have some additional information. So feel free to send an email to the marketing team at the email address provided, and I would be happy to take a look at your specific situation.
Thank you. Next question is, does AccuSource provide forms for the employer to use for adverse action responsibilities?
Yes, we do provide sample forms that can be used, but as I always recommend, you should definitely review those forms with your employment attorney or outside counsel to determine if that form specifically meets your needs. For example, there can be background screening for employment, but also for volunteer work and students. So it's really critical to make sure you're reviewing the forms with your legal counsel to make sure that they do meet your needs.
Thank you. The next one, is it okay to still see records back further than 7 years?
Again, that depends on the jurisdiction that you're in. In general, under the FCRA, you can see conviction records past 7 years, but it really varies from state to state. California has a restriction, Maryland has a restriction. So feel free to send an email to the marketing team, and I can definitely look at your jurisdictions to see what you might be facing.
Right. Next question, and it has a little bit of background. It says, we are a nonprofit who screen volunteers, especially those who work with children. If ban the box applies in my state, does that only apply to employees or also volunteers?
I would need to take a look at your specific jurisdiction. Since ban the box rules are different, it might specifically say that it's only for employment, but it might also apply to other types as well. So again, please send an email to marketing and we'll get back in touch with you.
Next question. If an applicant, excuse me, if an applicant requests it from AccuSource during the background check online process, does AccuSource send along a report to the applicant? Again, only if it is requested by the applicant. Let me know if you need me to reread that.
Okay, so from what I understand, you are wanting to know if anytime we run a background check, if a report's sent to the applicant. The answer to that is generally no. They will receive one if they request it, which they can always request a copy. And then for those customers who we provide adverse action processing for, they do receive a copy of the report if the client is considering taking adverse action and does take adverse action.
Next question. Is a nonprofit organization, specifically a 501c3 religious organization, required to adhere to the ban the box regulation?
This is very similar to the previous question, and I would like to know more about the jurisdiction to research it a little bit further.
Next question. Do you need to send adverse action for volunteers?
Yes. Anytime you're taking an adverse action, you should definitely send that information. Even if they're not being paid, they are receiving some sort of a benefit for what they do, so definitely should be sending adverse action.
Next question. As an employer, when am I required to provide the new security freeze notice?
Okay, so generally, the times that an employer would provide the FCRA summary of rights is during the adverse action process. So just any time that you're sending the FCRA summary of rights, you should definitely be using that updated one. And the nice thing is the CFPB did update the official summary of rights that they have provided. So it's at this point, you don't have to edit your own document and send that out. You can use the fully updated one. Dustin, did you have any further questions?
Yeah, no, I apologize. Yes, we just got one in, and you may have just answered it or close to it. Does AccuSource send adverse action letters for clients?
So it is a service that we provide, but you must specifically sign up for it. We could handle the pre-adverse action letters, and there's also a button to press for adverse action. But it's definitely a service that we could provide, and you can obtain additional information by contacting marketing.
Next question. I am an employer with employees in different states. How do I ensure in compliance with ban the box laws?
So if you have employees in a number of different states, you may want to consider removing criminal history questions and checkboxes from your application completely. While it's possible to have different versions of the application to meet the different requirements, it's a lot easier to maintain just one uniform application. You should also review your hiring process against ban the box laws to ensure it meets potentially different requirements. But truly the easiest thing to do is just remove those questions from the application and from the initial hiring process completely.
Okay. Next question. When will AccuSource start using the new form?
I'm assuming that they mean the new FCRA summary of rights form with the consumer freeze notice, and we are already using that. It's already in place.
Next question. Do you anticipate all states removing salary history?
It's becoming more of a trend. As of now, there's less jurisdictions than, say, ban the box, but as gender discrimination and equality issues become more prevalent in society and more talked about, yeah, I'm guessing that more and more states and jurisdictions will start removing the box and start requiring that salary histories not be included.
Next question. What do the recent standing decisions related to Spokio mean for employers?
The recent decisions show how different courts are viewing the injury and fact requirement discussed in Spokio. An injury must be concrete or measurable. So because of that, a bare procedural violation of the FCRA may not be enough on its own. What's that really mean, though? Under the FCRA, you have to provide a disclosure on its own. Say that you were to provide a disclosure and a release of liability on the same page, that disclosure is no longer standalone, and this would be a violation of the FCRA. However, just because they're violating the FCRA on this procedural front doesn't mean that the applicant doesn't have to prove injury. They still need to prove specifically that they were injured in a concrete way. This makes FCRA lawsuits more difficult to prove, which is definitely a help to employers. However, just because it's a lot harder to win an FCRA class action based on this doesn't mean that you should subject yourself to that in the first place, because obviously they're very expensive to defend against.
Next question. For jurisdictions that do not allow salary history, can they ask for desired salary?
Generally, yes. I know a couple of the more recent jurisdictions that have salary history bans have specifically said that you're still allowed to ask about salary, about like the salary the person desires, but I would look at the specific legislation to see if that's covered as well.
Next question. I am in HR for an employer in a state that just legalized recreational marijuana. We also have medical marijuana. How do I protect my workplace without violating the rights of marijuana users?
Okay, first, keep in mind that even with legalized recreational and medical marijuana, an employee typically cannot use marijuana or be under the influence of it on his or her employer's property. As with alcohol, you can set up guidelines, different drug testing policies, stating that they cannot use marijuana on your property. That being said, marijuana is more difficult than alcohol right now. There are some tests to determine if someone is under the influence of alcohol in that exact moment. But with marijuana, there is no test for current usage, at least not a test that is widely used or accepted. So the best approach is to review the state's legislation to see how it affects your company. You can then review your drug testing and drug-free workplace policies to make sure everything's in line with the new law. Basically, you want to be uniform and have solid policies that clearly lay out your company's treatment of marijuana. Being uniform is key.
Thank you. Next question. Are you able to verify previous salary once you have hired the candidate if you're not allowed to ask the salary question during the interview or before hire process?
That is going to depend on the jurisdiction and how their salary history ban law is required. Some of them specifically allow you to verify past history if the applicant voluntarily disclosed that to you. But because the law can be so nuanced, I would recommend double checking your specific jurisdiction to verify whether or not you can do that.
Next question. What do you suggest, or can you give a couple of examples for employers when addressing the salary questions?
So for example, if you are allowed to, try to think of a couple examples. See, it's kind of hard because it differs so much, but I agree that it should always be after an offer has been made. Shouldn't ask about salary history before that. You can definitely ask for desired salary unless the jurisdiction specifically says that you're not allowed to. But without seeing the specific law and knowing the specific situation, it's kind of hard to give an example of a specific time when you can and cannot ask for salary history.
Next question. Do you suggest being transparent and listing the salary range when posting job openings?
I have seen lots of employers doing that, so I don't think it's necessarily a bad thing so that people know what to reasonably expect, but that's more of an HR decision rather than like a background screening compliance question.
Right. Next question. With the change in marijuana laws, is it recommended that employers remove marijuana from their testing panel?
Not necessarily, because there could be a situation where someone is using marijuana illegally. Recreational marijuana, that's a different story, but if you're in a state that only has medical marijuana, you might still want to test for it and then determine if they have a prescription card showing that they are allowed to use it. When I've done drug testing in the past, we would be able to find out whether or not someone who tested positive for marijuana did have a valid prescription card. So in that case, we wouldn't necessarily want to take employment action against them unless we were allowed to in that specific jurisdiction. So you don't necessarily have to remove it, just be aware that you should treat everyone uniformly so you don't run into discrimination issues.
Next question. What if we found someone under the influence of alcohol, but the only policy we have is in our handbook, and it does not specifically state the process, just that it is not allowed, particularly for safety reasons? Can we still terminate them?
I don't want to give a very specific answer since this is a very specific legal question, but generally you want to outline your specific process for testing. So for example, how did you know that they were under the influence of alcohol? How did you know to do a reasonable suspicion drug test? Was it one supervisor who noticed that they were acting strange? Was it two? So it's very important to outline those policies because otherwise you could come back and face a lawsuit for unlawful termination, or they could go and try to claim unemployment. So the best thing to do is to be able to point to your policies and have those processes clearly outlined in your manual.
All right, next question. Salary requests should be removed from applications, yes or no?
Again, not necessarily. If you're a multi-state employer, I would recommend removing them from the applications just so that way you're consistent across the board. It can get very messy if you have multiple applications for multiple jurisdictions. So being uniform with one application that removes that type of question is definitely recommended.
Next question. What if a workers' comp injury occurs and a drug test was positive? How do you address workers' comp injury?
I will admit that that's not my area of expertise, but I would imagine you'd have to be careful because of the ADA and possible medical reasons. But I would recommend getting in touch with your legal counsel or someone who specializes in workers' comp law.
All right, next question, and we're getting more specific, so this is good. Is it okay to ask in an interview if they would accept a job if offered a specific rate of pay?
If you're in a jurisdiction that has a salary history ban, then I would not ask that during the initial interview. Some of those laws are very specific about when you can ask those types of questions. Feel free to email marketing and